All right, welcome back. We've got a fun one today, I hope. So, for those of you who are new, I'm Joe. I'm an attorney licensed to practice in Utah. So, we've got two things to cover, basically. First, I realized pretty much as soon as I ended yesterday's video that in my loopiness, it had been a very long video, I realized. And by the end, I was done. But I realized I should have clarified something about the absolutely hilarious ending of that. So I realize my coverage of the Scofield versus Guillard TikTok psychic defamation case gets fewer views than my sovereign citizen coverage. That's unfortunate because she's just as crazy as sovereign citizens. So basically, yesterday we covered Professor Scofield's motion for partial summary judgment, and then Ashley Guillard, the TikTok psychic's opposition to the motion. And the the hilarious end basically was in her prayer for relief at the end of the motion, she asked for $1 million in um, punitive, basically against Professor Scofield, Rule 11 sanctions. She asked for the case to be dismissed with prejudice, but she also asked for the court to revive her counterclaims that had already been dismissed with prejudice. But she notably did not ask the court to um, deny the summary judgment motion, which it's just hilarious. She asked for three things that were unrelated to her opposition motion, but didn't ask for the one thing her opposition motion actually was about. So I basically I realized I should have discussed the real life implications of that. And the reality is there are no real life implications because we've discussed this so many times, especially because Delete Laws uses his pro se status as a sword, trying to say anything I do wrong you can't hold against me because I'm pro se, therefore I've done it right and you have to rule for me. And he uses that both for his pleadings being absolute crap, but also anytime he gets the rules wrong, he's like, whoa, I'm pro se, so that's fine. But I've tried to pound home the point that the courts say, you know, pro se pleadings need to be interpreted liberally because even if they're inartfully pled, if the court needs to read into the meaning of it. They can't write the motion for them. They can't make the argument for them. But if the argument's there, but they're maybe not quite in the right way, they'll take it as the argument it probably should be. But they need to strictly follow the rules, the federal rules of civil procedure. So basically, despite Guillard failing to ask for the summary judgment motion to be denied, the entire motion up till that point had basically been her opposition to summary judgment. So the court is going to construe it as opposition to the summary judgment motion. Now, summary judgment should still be granted on the merits, but her failure to ask for it, while hilarious, won't actually have anything, you know, at least no, it won't have an impact. But, you know, speaking of psychics, clearly I am a psychic, because the subject of today's video is the sovereign citizen Eddie Alexander Banks. Why does that make me a psychic? Because this video was provided, or at least exposed, by Van Balian a couple days ago. And literally the night before Van posted his video, I was trying to remember Eddie Alexander Banks' name, thinking, I haven't heard from that one guy in quite a while. I haven't seen a video on him. I wonder what he's up to. And the very next day, Van Balian posts a video on him. So clearly I'm psychic. Ashley Guillard's a fraud, but I am a psychic. You're welcome. And for those of you wondering, who is this Eddie Alexander Banks? I don't think I've done a video on him before. Artie at Artie's Corporate Fiction has done several, and I think, you know, of Artie's laughing fits, just absolutely losing his mind, Banks is the one that has provided the best Artie laughter meltdown when he tried to basically seize a courthouse by scotch taping a notice onto the door and you know, got me twisted. And it's just, it was hilarious. So but I haven't looked for it. So this video is, as you can see, the City of Everett hearing. So it's in the City of Everett Municipal Court, low-level misdemeanor courthouse. I really feel sorry for the City of Everett, because not only do they have to deal with Eddie Alexander Banks, but they also have to deal with Glenn Serio. So no city should have both of them to deal with it. That's just too much. So basically, what we're going to see is Eddie Alexander Banks should be held in contempt. He's not going to be held in contempt. And at the end, I'll tell you why he's not held in contempt. Got it? Let's hit the video.
The prosecutor will try to do that by calling witnesses and by presenting other types of evidence, such as writings, photographs, or lab test results. You have the right to please rise.
So that little spiel about the prosecutor providing evidence, that sounded like it was just basically the pre-court video that the courthouse plays, introducing defendants to court, letting them know what to expect. Some courts do it, some don't. Some require, basically, that, you know, they say court starts at 9 o'clock, be there at 8:30 to receive instructions. That's the instruction. Of course, as an attorney, I show up 9 o'clock because I don't need the instructions. Covert recordings are always the best recordings, of course.
And Miss Geller's cousin, she's making her way over. Good morning. Hi.
So this is basically just the morning cattle call.
And Miss Geller, what's your date of birth? 1/12/72. Right, I know I came in the middle of the video, so I forgot about that. Usually we cover the 11 or the 8:30 a.m. calendar. So did you have a chance to go through the high school information?
Let's see.
All right, thank you. If you have not guilty, you will enter. It looks like the court previously found probable cause. What's the city's position with regards to communication?
I haven't watched this other than Vans.
Any objection?
So I don't know if this is all just dead space or if he's got something good in it. I agree, Eddie. Sigh. Those are some great fluorescent lights on the ceiling. All right, that's too much of that. We'll go to there. I'm upside down.
Mr. Bates is asking the court to quash the warrant that was previously issued at his last hearing. And I believe the clerk has already been handed forward a 1077 order for a competency evaluation, which defense is requesting to take place out of custody.
Okay, is he wearing lace-up like gauntlets on his wrists? He's ready for battle. He's ready for battle. That's I mean, yeah. So basically, if you couldn't hear the defense attorney, he has a warrant. They're asking to quash the warrant, and I wasn't sure if it was the prosecutor or the defense asking for a competency evaluation. So basically, someone's saying this dude's nuts. He might not be competent for trial, but we want him to be. Basically, we want the warrant quashed. So, don't take him into custody right now, and we want the competency evaluation to happen while he is out of custody rather than taking him into custody right now and doing the evaluation, which, it's since it's in the Everett Municipal Court, it's, that's probably the right way to do it. Of course, he's got a warrant. So either he's been a naughty boy in court to receive a warrant, or more likely he didn't show up to court. So maybe, he should be, or at least have his bond re-examined, higher bond to ensure attendance. But either way, I think that the request for a competency evaluation plays a big part in what does and doesn't happen in the rest of this video.
The city is no objection.
All right, so I'm going to sign
an out-of-custody evaluation since Mr. Banks is custody for today. And what we should do is set a review hearing, probably in a couple of months. I think that we need at least a couple of months, just based on the time frame and waiting for the evaluation. So, Rick, you suggested.
Courts really need to invest in more specialists, basically. If you couldn't hear, the warrant was quashed, no objection from the city, and the judge says, yeah, we're probably looking at setting the next hearing a couple months out because that's what it's going to take to get him evaluated. So they either need to increase their budget to pay private practitioners, increase the budget to hire more basically practitioners as state employees, you know, the state mental hospital, whatever, or, you know, have a higher threshold. Have Eddie Alexander Banks, I don't think he's incompetent. I think he just has bad ideas. That doesn't mean he's incompetent to stand trial. He just doesn't believe in the courts. That's unfortunately not incompetence. We need to stop playing games with people if they're clearly, you know, unable to assist with their defense, but putting forward frivolous, fanciful defenses. Hey, you understand the charges against you. You just don't agree with them. That's fine. You can, you know, not agree with going to jail. It's going to happen.
Like a Monday, 9 or 10, to a few months, like November 6th at 9. So Mr. Banks, would November 6th at 9 a.m. work for you for your next hearing?
No, I would like to give notice of fraud on the court and serve documents to all parties involved.
So November 6th, that's this past Monday. That I wonder if it happened. But it's not possible because he wants to serve a notice of fraud on the court on all parties, which frankly isn't a thing.
Okay, so I don't know what that means because that's not in our normal procedure. So you're welcome to do that if you need to. But
Okay,
I'm just
so
asking
you're-
you about your next court date. Is that November 6th work for you?
No, I don't consent to any further court dates.
All right, so let's set November 6th, and if you don't appear on November 6th, then you should want your arrest, okay? All right, so I set that date, I send the order, and we'll make sure to get a party spot at that.
Ma'am, what's your name again, please?
You can talk outside court.
Sir, you represent the city?
Yes.
May I have your name, please?
Sir, you're gonna have to move along because I have other cases that I need to call, so you can ask those questions.
Sir.
So this is frankly one of the things that really pisses me off about the sovereign citizen shenanigans in court is, you know, he hasn't shown us the gallery, but there might be 50 people sitting there waiting for their hearing. They took off work. They're just waiting their turn. And, you know, that's why I called it the cattle call at the beginning, the morning cattle call. You want to get in and get out as fast as you can. Get back going with your day. But, you know, this buffoon is causing problems. He's causing delays. He's holding everyone else up and, you know, demanding everyone else's names. You know, he asked his attorney for her name. She said, yeah, let's talk outside because, you know, courts aren't for conversations. They're not, you know, they're for court. And then he switches his focus to the prosecutor. You work for the city? Yeah. What's your name? You know, D's nuts. It doesn't matter. He's got qualified immunities. if you try suing him, you can't. You know, you'd sue the city of Everett for malicious prosecution, but I doubt it's malicious prosecution because the dude's a sovereign citizen. He's probably driving without a license, driving without registration, insurance. Could be something else, but it's in the city court. It's going to be something along those lines, at least that level. So,
Sir, may I have your name, please?
Mr. Banks. Mr. Banks.
Sir,
Mr. Banks.
may I have your name, please?
Sir, sorry, I'm not allowed to talk to you at the moment.
Mr. Banks. I
Okay.
need this.
so if you couldn't hear that, the prosecutor said, "Sir, I'm not allowed to talk to you. You're represented." That's kind of true. It's a good excuse from the prosecutor. So the general rule is criminal defendants who are represented by an attorney, that prosecutors aren't supposed to talk to them. They're not supposed to discuss the case with them. So technically, he could give his name, but he doesn't have to. His attorney, the defense attorney, knows the prosecutor's name. She can give it to him. She doesn't have to either because, you know, first off, she's a public defender, I'm assuming, so he's not paying her. So she has to represent him. She doesn't have to give him everything he wants. So either way, the prosecutor could talk to him, but not about the case. But it's an easy out for him. So good job.
Step back, okay?
All right.
All this information is public record.
Absolutely. Here, I'm giving you judicial notice.
You need to hand it to the clerk.
So that is a huge, huge, huge problem. Just walking up to the bench, that's a way to get shot. At the very least, it's a way to get tackled or tased or, you know, handcuffed. That is, you know, in virtually any other setting, that's just walking up to someone. But that is a form of major aggression in a courtroom. You've got to ask for permission. If I walked up on the court like that, I mean, part of it would depend on my relationship with that specific judge and, you know, the prosecutor and public defender that are in that judge's courtroom every day for multiple hours. They kind of develop a rhythm. So, like, you know, if Debbie Davis walked up on Judge Middleton, it's probably not going to be a big deal. If, you know, Paul Gibson, a frequent appointed attorney, did, he might get away with it. He might get reprimanded. If I did it, I'm not a Michigan attorney, so if I did it, I'd be liable for arrest. That's contempt of court. That's a big deal. And him refusing to back up when the judge tells him to, that's an even bigger deal.
Judicial notice.
You need to stand
What's your
back.
name, ma'am?
You need to stand back. Sir, you need to stand back.
Emily. Last name, Emily.
You need to go back. All right, I'm gonna need you to move so I can call the next case.
So this is the thing. You force me to come here, and then you
No,
limit,
you
and
got
then
a
you won't.
warrant,
You, no, hold on,
and
hold on,
I
hold
let
on,
you come
ma'am.
here so that you can question
Everything
the
that I
warrant. You need to
filed
step back, or
in
else
the
we're gonna have to
case,
call
everything that I filed in this case is being ignored. You want to?
That's because, number one, you're represented. So anything you file isn't official. It needs to be ignored. Your attorney files things for you because you're represented. You weren't forced into court today. You set this hearing to quash the warrant. Otherwise, you'd be there in a jumpsuit and cuffs if you had been picked up on the warrant. So the they didn't force you in today. Yeah, you didn't have a choice over being criminally charged other than, you know, breaking the law. But I mean, you don't have a First Amendment in the courtroom, at least not an unfettered First Amendment. The courtroom is not a public forum. Like you, it's not even a limited public forum. It's a non-public forum. The judge gets to decide who speaks, when they speak, what they speak about. If your case is done, you do not have the right to speak. You do not, well, I mean, you have the right to sit in the back, maybe. You know, that's not unfettered either. But you do not have a right to be in the well. You do not have a right to be at counsel table. You do not have a right to be addressing the judge. She has said your next date is November 6th. Goodbye. That's the end.
Want to play with my life, take away my ability to
Alright,
make a living
you need to
with
leave.
fraudulent
You
proceedings.
need to
It's
exit my
unacceptable.
courtroom. You need to exit my courtroom. It's all in this.
Do you
standard
believe
procedure.
you're above arrest?
I need you to leave my courtroom.
Do you believe you're above arrest?
I need you to leave my.
Do you
On the bench, she is. So, yes.
believe you're above the law?
Don't keep approaching me. Don't keep approaching me. I'm gonna ask you kindly to please leave the courtroom now, okay?
This
I
is
don't
my
want
court.
this to get nasty. I want you to leave.
Yeah, because I want him
I'm
to
gonna
come
ask
arrest you.
I'm gonna ask you to leave, okay? It's fine. I will quash your warrant. You need to leave, please. I'm asking you nicely. Just please leave.
Respect the paperwork, lady.
So that right there is contempt, obviously. Respect the paperwork, lady. Your paperwork, frankly, to quote Ashley Guillard, it's not worth the toilet paper it's printed on. It's garbage. Your paperwork means nothing. But there's so many instances there he could have been arrested for contempt. The first time he walked up on the bench, the second time he walked up on the bench, the respect the paperwork lady, the are you above the law? You know, are you above arrest? This is my courtroom. You know, he's bordering on not just contempt charges, but actual. I don't even know what the exact charge would be, but uh, you know, menacing, threatening a public official, something along those lines. This is serious stuff. And one thing I did notice though is I don't see any bailiffs or sheriff's deputies in the courtroom at the moment. And that's not uncommon in justice courts. They're low level stuff. So you go through security to get in them, but there might be just one or two deputies and they're sitting outside the door at the metal detector. So unless the judge hits her panic button or, you know, someone goes out to get them, there's no one to immediately arrest this moron. That doesn't mean he won't get arrested eventually. Sadly, not in this video, but you know, he's lucky he's not trying this in, you know, the district court, or here in Utah it would be district court, in like Michigan, Maryland, whatever, circuit court. You know, try this in federal court and oh boy, you're in trouble. It's, you know, it was the guy was more aggressive than this, but he was shot and killed rushing the bench here in the Utah Federal District Court. It's it was, you know, it's a big deal. So
I'm not playing with you.
All right. So what did I
Respect and honor. That's what it is. I've given you judicial notice. If I have to come up in here with men myself to take custody of you, I will.
So that is an overt threat. That should be charges, frankly. But I've given you judicial notice. That's not a thing. The judge can take judicial notice, but you don't give judicial notice. That's ridiculous. It's and the judge can take judicial notice that you're trying to give her ridiculous paperwork. That doesn't mean much. It just means the court acknowledges that you're trying to do it. But you can't give judicial notice because, you're not a judge. So you can't give judicial anything.
Because you will not use people's power for this county, in this city.
So the guy in the suit in front of him probably was a bail for court security. So. Ooh. Apparently we needed a headphone warning. So I mentioned at the beginning, there's a reason he wasn't arrested for contempt. And it's because there's questions of his competency. I mean, that frankly, they could bring contempt charges, have a hearing in front of a separate judge and actually prosecute him for contempt. But I hate to say it, but I think the judge made the right call here, because if there are questions of competency, is he competent to not be in contempt? Yeah, basically, if he's incompetent, does he know his actions are wrong? Does he know you're not supposed to act like that in court? And so since they've already set him for a competency evaluation, should he spend a day or two in jail if he's not competent? Of course, send him to the funny farm. That might be an option. But he hasn't been evaluated for that either. And the judge already ruled, yeah, we're not going to hold you pending your evaluation. So, but like I said, I frankly, if I'm the prosecutor, I might be looking at, intimidating a public official or whatever the charge is. I don't know what it would be, especially in Washington, because that's threatening judges is not okay. It's never okay. And once he comes back competent, they should look at charges. Of course, once he comes back competent, he's in court again, and assuming he shows up, he said he doesn't agree to any court proceedings, so he might not show up again. There might be another warrant, but we'll see. I mean, this video is unlisted, so you can't go to his page to watch it. You've got to follow the link to get to it. He might already have a video up, an unlisted video of the November 6th court hearing, or he might not have shown up. It might have been postponed. He might not have been evaluated yet. So I don't know where he stands yet. Like I said, I don't even know the charges. But what I do know is this was absolutely contempt, but the judge, you know, if there's any situation to let it slide, this was the one. But that's why I shouldn't be a judge, because I'd be a real hard ass about it, and he absolutely would be locked up right now. So with that, do all the YouTube-y stuff. Like, share, subscribe. I will see you soon for the next one. Bye-bye.